Hey everybody. So we've reached the last lecture in this deep dive into the intersections of text and data mining research and copyright law. And now we reach the final topic, which was, what does international law have to do with it? And towards that, we're going to turn to two very close partners in this overall project. In fact, we have Martin Senftleben, who's the director of IFIR, the Institute for Information Law, and is a professor as well at the University of Amsterdam. And we have Joao Quintas, who is an assistant professor at IFIR. Martin's going to present some of his article about why copyright laws should not worry about international copyright law. So Martin, over to you. Welcome. Thanks for being here.
So as Sean has explained, at this final or semi-final stage of the lecture series, we turn to issues of international copyright law and ask the question about the research impact of the international protection framework. I have chosen as an overarching question for the presentation, what are the restraints, what are the enabling conditions created for research rights when we look at international copyright law? When we look at individual impact factors, then I guess it's fair to say that, first of all, which exclusive rights impact research activities in countries that are bound to follow these international rules? And then I think, broadly speaking, we can refer, when we look at text and data mining activities, modern types of research, we look at the right of reproduction as it has been recognized in the Berne Convention, and also when it's about sharing TDM material, CDM corpus within research consortia, within research groups, the right of communication to the public may play a role as well. And this right of communication to the public has become broader and broader in the WIPO Copyright Treaty at the international level. Then, of course, exclusive rights is just the first step. If we arrive at the conclusion that TDM activities could fall under an exclusive right from an international perspective, then the next question could be which exceptions and limitations, which flexibilities are available in order to create a national framework that allows for modern research like TDM research, even though it falls under one of the exclusive rights. And then at the international level, as you may know, the so-called three-step test that we know from the Berne Convention, the TRIPS agreement, the WIPO Copyright Treaty, provides a general framework that defines the scope of flexibility for national policymakers. Of course, we also have territoriality issues, the so-called cross-border issues. So the question, once the TDM corpus has been created, a TDM data set is available in one country, can this easily be shared also with researchers in other countries? When we do a case study on national approaches to text and data mining, we see that countries around the globe or regions follow quite different approaches. In the United States, the modern forms of research, TDM and so on, have been regulated by the courts, basically following fair use precedents and developing specific fair use rules for text and data mining. In civil law jurisdictions like Japan, we find a statutory exemption, so something that places TDM use outside of the scope of exclusive rights in a relatively broad manner. And then that is what I would call the most traditional approach. In the European Union, specific exceptions have been adopted that clarify in the legislation itself under which circumstances TDM research would be permissible. But as we also have heard already, there are quite a number of countries that have not decided yet, that have not chosen a regulatory model yet. So the question is, if a country still has to make these choices and wants to make choices that are compatible with international law, which is the model that one should follow? Is there a particular set of international requirements that dictate a particular national implementation for research rights? I start with the example that personally I find the most specific, if you want to say most restrictive one, and that's the specific exception for academic scientific research that has been adopted in the European Union. It allows reproductions and extractions made by research organizations and cultural heritage institutions in order to carry out, for the purposes of scientific research, text and data mining of works or other subject matter to which they have lawful access. When you look at this rule, you could think, well, I mean, that's good news. The provision clearly places specific types of research use outside of the control of copyright owners. But as with all these specific rules, the devil is in the details, of course. What we see here is, first of all, a focus on scientific research. What about investigative journalism? Would that fall under this rule as well? Most probably not, because there is quite a traditional restrictive definition of research organization in EU legislation as well. Then the legislation is clear on saying the research organizations must be organized in a way that makes them independent from commercial influences. So what about public-private partnerships then? Under which circumstances can private partners of research groups also benefit from this exception? Then we see at the end of the provision a lawful access requirement. Well, if a research institution first has to ensure lawful access, then this always means that rights owners have quite some influence on the terms, because contractual terms could be used to in some way impact the research process. And then the words reproductions and extractions in EU legislation only covers acts of copying. It does not cover data sharing. So the making available of a TDM corpus in a broader research consortium, for instance, would not fall under this harmonized Article 3.1 of the new directive on copyright in the digital single market. This is why certain member states like Germany have added further rules saying that in a research consortium, there must also be room for sharing TDM data sets within the group members. The Japanese legislator has adopted a broader provision covering generally exploitation in any way and to the extent considered necessary for using the work in a data analysis. And then the provision explains in a bit more detail what data analysis would actually mean. So here we see a markedly different approach. The central criterion in this provision is use other than for enjoyment. And the Japanese legislator has added a requirement that the use must not bring unreasonable prejudice to right holder interests. Those of you who know the three-step test by heart, they will immediately see that this is a part of the three-step test. The third test refers to unreasonable prejudice to legitimate interests of the right holder. So this has been included, embedded in this Japanese provision. It is my understanding that the fair use provisions, fair use rules in the United States would also offer a much more flexible approach than what we see in the European Union. When we look at international law, international copyright law, what is actually necessary in order to ensure compliance with the international rules? Well, as a starting point, we can, of course, look at Article 9.1 of the Berne Convention, which includes the general right of reproduction and says authors of literary and artistic works protected by this convention shall have the exclusive right of authorizing the reproduction of these works in any manner or form. When you read this provision, and in particular the magical words at the end, in any manner or form, you could think intuitively, well, this also covers reproduction for TDM purposes, because in any manner or form sounds very broad, very inclusive. If the conclusion is that the international right of reproduction also regulates TDM, then we immediately arrive at Article 9.2, which says if there is a relevant act of reproduction, then any limitations of this exclusive right have to comply with the three-step test. These are the three conditions. The first step of the three-step test is the question whether the use constitutes a certain special case. The second test is whether the use conflicts with a normal exploitation of the work. And the third and final test is whether the use causes an unreasonable prejudice to legitimate interests of copyright holders. We see immediately that these rules, of course, offer lots and lots of room for interpretation. So I'm not saying that a TDM use privilege at the national level cannot survive the three-step test. Quite to the contrary, I'm convinced that the national rules that we have seen, whether it's fair use or whether it's in Japan, the broad exemption, they all comply with the three-step test. But the three-step test as an open-ended norm offers, of course, lots and lots of room for controversy, for raising doubt about compliance with international law. This is in particular clear when we look at case law that we find internationally. There have been, before the WTO, 3 decisions, one in copyright, one in trademarks, one in patent law, that deal with interpretations of international three-step test provisions, not only in copyright, Article 13 TRIPS, but also in patents, Article 30 TRIPS, and also in trademarks, Article 17 TRIPS. With regard to certain special case, the first test of the three-step test, it follows from these decisions at the WTO level that panels can be tempted to take a quantitative approach and to ask, okay, how large is this use? What is the number of potential beneficiaries? What is the volume of exempted use? Quite clearly, if we use this as a yardstick, then TDM research could be accused of, well, using many different sources, whole catalogs, whole repertoires of protected works. At the same time, we can say the number of beneficiaries, at least when we focus on scientific research, is relatively limited. Another approach would be to ask rather qualitative conceptual questions. What are the individual circumstances of the use? And there we could say TDM, for instance, is a very specific type of using copyrighted material, a very specific form of use in a research context, specific technical equipment. Finally, when we look for alternative approaches, a normative approach, saying that this is something about balancing copyright protection against other fundamental rights, like freedom of expression, freedom of science, and so on, then there is a very strong policy objective underlying TDM exceptions, TDM limitations. But actually, if I'm honest, the WTO panels have not focused too much on these normative approaches, I guess because they might be a bit hesitant to make judgments about the legitimacy of policy approaches developed in the WTO member states. So once again, we see certain special cases offers lots and lots of room for different interpretations. And while it is possible to argue in favor of broad TDM exemptions, counter-arguments are conceivable. The same with regard to conflict with the normal exploitation, where the WTO panels have looked at empirical facts. What is the general mode of exploitation that is used by the creative industries? How would the exemptive use impact those traditional modes of exploitation? But also normative approaches, asking whether the exemption from copyright covers an area of exploitation that is essential to the achievement of the goals of a protection regime. Second approach, which is closer to copyright, because the copyright panel focused on this second approach, was to ask whether there are actual or potential forms of exploitation that are of considerable economic or practical importance. And now again, you see the ambiguity of the three-step test. If you follow the second approach, asking, is there a promising new market? Is there a potential new form of exploitation that could lead to substantial revenues, that we could say, well, yeah, I mean, if you put a tax, a copyright tax on all types of TDM research, and of course, this can generate quite some revenue. So this might have relevance. But then when we look at the approach taken by the patent panel before the WTO, we could say it is not an area of exploitation that plays an essential role in the achievement of the goals of copyright policy, because it is not use of the work for entertainment, for enjoyment purposes. It is for something else. And then, of course, generally the question is whether in comparison with traditional modes of exploitation, TDM research, which is still a very specific type of use, could ever generate revenue that is comparable, that really plays a role, that contributes to the lion's share of the income of the creative industries. Turning to the third step, legitimate interests, there's a normative approach that we find in 2 WTO panel decisions, in the patent area and the trademarks area, where the panels have referred to interests that are justifiable in the sense that they are supported by relevant public policies or other social norms. If you follow this approach, we could say, well, it is very much the question whether scientific publishers have legitimate interests in the area of text and data mining at all, because actually they get many of the research results more or less without investing in it, because it is the academic system that finances university positions, that finances research, and they reap the fruit of all this research without paying for the research efforts and all the evenings and weekends that we spend on writing books and articles and so on. They don't pay the hours for this. They get this basically for free. There's also a legal positivist approach, which we see in the WTO decision of the copyright panel. And here the panel at the WTO focused very much on the interest in the economic value of the exclusive rights conferred by copyright on their holders. And this would be a position that makes it easier for right holders, for the creative industries, to argue that this is a promising new market and that remuneration should be paid. So the question is, from an international perspective, is this whole discussion really necessary? So I would like to leave the fascinating world of the three-step test and take a step back and ask the more fundamental question, is international compliance something that we have to worry about? Is the right of reproduction really so broad that TDM activities fall under this right recognized at the international level? And this brings me back to a discussion on the right of reproduction that took place at the 1996 diplomatic conference that finally led to the adoption of the so-called WIPO Internet treaties, the WIPO Copyright Treaty and the WIPO Performances and Phonograms Treaty. So at the time, 1996, the discussion was about temporary copying. Article 7.1 of the basic proposal for what later became the WIPO Copyright Treaty provided as follows: the exclusive right accorded to authors of literary and artistic works in Article 9.1 of the Berne Convention. So this was an attempt to clarify the scope of the right of reproduction with regard to permanent or temporary copying. Well, the scope of this right of authorizing the reproduction of copyright protected works shall include direct and indirect reproduction of the works, whether permanent or temporary, in any manner or form. In any manner or form was not a new element. This is something we find in the current text of Article 9.1 of the Berne Convention. So the new element was really the question of temporary copying. At the time, this question was so relevant because the internet kept the international copyright community busy, and in particular acts of browsing, acts of caching, these temporary copies that are necessary to make the internet functioning well and makes the internet sufficiently fast and so on, was something that required, it was felt, international regulation. And so the policy question was very much, should the creative industries, should the copyright industries obtain control over how the internet functions, how the internet is supported by acts of temporary copying? The basic proposal took as a starting point that, well, the question was crystal clear, very clearly, these acts of temporary copying would fall under the international right of reproduction. The right of reproduction could not be more expensive in scope, is something that we read in the basic proposal. And the basic proposal and the discussion at the conference also reflected the widely held understanding that harmonization was desirable at a broad understanding of the right of reproduction. The member states of WIPO, being confronted with this question, well, there is a new category of copying, temporary copying, browsing, caching, something that has not been on the international agenda before. Should we automatically say this falls under the right of reproduction, or should we use our freedom as member states to say, wait a minute, we want to discuss this, and we actually think that this is not as crystal clear as the basic proposal tries to develop this. And so this in fact happened. The member states did not reach agreement on this provision. Singapore, for instance, feared that if temporary acts of copying would fall under the right of reproduction, then this would have far-reaching consequences in that fair use rights in the areas of researchers, libraries, and private use were in danger of being curtailed. And then this starting point about fair use and so on triggered an even more fundamental debate, which finally led to the question, what is the scope of this concept of reproduction in the sense of international copyright law? What is the scope of international concept of reproduction? Denmark then declared that temporary copying did not constitute reproduction within the meaning of Article 9.1 of the Berne Convention altogether. And that was a remarkable statement because, technically speaking, if temporary copying does not fall under the international right of reproduction at all, then international copyright law does not play a role in the regulation of this type of use at the national level. So that's a position that gives lots and lots of freedom to national policymakers to decide on how they want to regulate this, at the time, new category of copying, the temporary copying. And now, surprisingly, at the conference, this quite radical position, which Denmark had expressed, found further support. So Sweden, Norway, Switzerland said, yeah, we share this view of Denmark, that this is a category of copying that has not been considered before. The African group summarized the discussion by saying, temporary reproduction does not as such constitute a reproduction within the meaning of Article 9.1 of the Berne Convention. So very clearly taking this position that this type of copying is outside of copyright internationally altogether. And then they explained there are a couple of specific features of temporary copying that lead to the conclusion that it falls outside of the scope of the right of reproduction. Finally, we have an explanatory note made by Krulak. They said that Article 9.1 of the Berne Convention establishes the right of reproduction in any manner or form. In view of the fact that new technology has broadened traditional forms and manners, it has become necessary to redefine the scope. So they said, well, this formula of in any manner or form does not indicate that we have to slavishly understand this as absorbing whatever new category of copying is arising. By contrast, we as the international policymakers, the member states of WIPO, we have the possibility of redefining the scope, discussing the scope of the right of reproduction in each individual case where a new category of copying arises. And so it has become necessary to redefine the scope of the right of reproduction and exclude from it those reproductions that are technically necessary for making the work perceptible or form part of a technical process and do not in themselves constitute the production of originals or copies of the work. So let me turn now to the current TDM debate. As I said before, in 1996, the discussion was about temporary copying. It was not about text and data mining as we discuss it today. At the time, member states at WIPO said, Article 9.1 of the Berne Convention is not this all-embracing right that automatically absorbs whatever new type of copying arises, evolves. By contrast, we reserve our right to discuss in each individual case of a new type of copying whether we think that it makes sense to let this fall under the right of reproduction in Article 9.1. So member states insisted on an individual assessment case by case. Without an international discussion and consensus, Article 9.1 of the Berne Convention, from this perspective, does not cover text and data mining because this has not been under discussion before. And it is easy to argue that text and data mining, very much like temporary acts of copying in 1996, is a very specific, is a new type, a new category of copying that is very similar to the specific status which in 1996 was given to temporary copying. In the US, then Michael Carroll, for instance, has made clear that TDM is only for computational research. In Japanese law, we see that Professor Tatsuya Ueno, who has written about the Japanese solution, says the broad exemption is possible because TDM use aims at neither enjoying a work nor causing another person to enjoy the work. And interestingly, in the European Union, Rosanna Ducato and Alain Strouvel have made similar statements. They say in TDM cases, the work, although it might be reproduced, technically speaking, in part, the work is not used as a work. It is not used to enjoy the expressive core of the work. Taking this and using this as a background to the current TDM discussion, then it is not clear at all that TDM use, TDM reproductions fall within the scope of the right of reproduction in Article 9.1 of the Berne Convention altogether. In 1996, when the discussion was about temporary copying, the opposite outcome was the final result. Article 7.1 of the basic proposal, which tried to bring temporary copying within the umbrella of Article 9.1, the right of reproduction, this basic proposal provision was rejected. So there was no clarification or broadening of the concept of reproduction beyond traditional categories in the treaty text itself. The only outcome of the conference was an agreed statement that was added to Article 1.4 of the WIPO Copyright Treaty. And this statement consists of two sentences. The first sentence was uncontroversial, was adopted anonymously. The reproduction right as set out in Article 9 of the Berne Convention and the exceptions permitted thereunder fully apply in the digital environment, in particular to the use of works in digital form. Commentators like Sam Ricketson and Jane Ginsberg point out that this statement does not have much value because it states the obvious. Of course, the Article 9.1 provision of the Berne Convention remains what it is. So with regard to traditional types of copying, like private copying, for instance, of course, we can say that private copying has evolved a lot over time. And then they point out that the true value of this statement is not so much reconfirming that with regard to these traditional categories of copying, Article 9.1 of the Berne Convention applies, but that this statement explicitly also highlights the importance to permit exceptions and limitations. The second sentence could be more difficult. It says, it is understood that the storage of a protected work in digital form in an electronic medium constitutes a reproduction within the meaning of Article 9 of the Berne Convention. And then when you read the word storage, then, well, in TDM cases, we have to admit that there is, of course, storage conceivable if you want to create a stable TDM data set, a stable TDM corpus. But still the question is whether the word storage in this second sentence really has the meaning of extending to new types, new categories of copying that have not been known at the diplomatic conference in 1996. So here's the true story about this second sentence. First of all, it was highly controversial. So there was no agreement on this second sentence. A vote was necessary to get it into the treaty at all. And the vote was 51 countries in favor, 5 against, and 30 abstentions. So not a very clear vote in favor. And when you consider that in total 130 countries participated in the diplomatic conference, then you see that the number of countries that voted at all was very limited. So we don't even know whether there was a true majority for this statement. So the reference to storage in this highly controversial 1996 agreed statement does not seem to provide any basis or any guidance on the current TDM discussion. It just doesn't make sense. This statement is not solid enough to say this is sufficient as an expression of an international consensus to bring TDM, something which was not discussed. Compliance with international law in the TDM debate is basically a non-issue, because when we understand the international norms, and in particular Article 9.1 of the Berne Convention, in their proper context and in their historical setting, then the issue of TDM has just never been discussed in the context of Article 9.1, and we cannot simply assume that 9.1 then has relevance to completely new categories of copying that have not been on the international agenda before. I think if the issue was put before an international diplomatic conference, we would very much see the same reaction that we have seen in 1996 with regard to temporary copying, countries not giving away easily their freedom to redefine the scope and also limit the scope of the right of reproduction from the very beginning in the light of a new type of copying. And this means that from an international perspective, countries that have not chosen a particular regulatory model yet are free to choose whatever model they prefer. So that's the point of the article, and I hope I have given a bit of further insight and an overview of the line of argument. Thank you so much.